Good morning, everybody, and welcome to today's webinar, HR Advice, Parental Leave Unpacked, where we'll be talking all about understanding maternity and paternity rights in the workplace. So my name's Alice. I'm going to be one of your hosts and presenters for today. But as you can see, I am joined by some very special guests from Advisor Plus, who will introduce to you very shortly. Now, today's webinar is one of the webinars in our Statutory Payments 2025 badge series, and that started towards the end of January, where you'll have the opportunity to earn your very own digital badge if you attend at least 4 of the different sessions that we're offering, plus our Statutory Payments quiz. So this is one of the sessions in that series, as I said, and we've got one more session left after this one, which is our quiz tomorrow. We'd love to see you all there. So if you didn't attend the last quiz, now is your chance to test your knowledge there. And let's move on to introducing ourselves. So my name's Alice, as I said, I'm a learning facilitator here at Sage, and I specialise in the webinars. So I do sessions on Sage 50 Payroll and Sage HR mostly, so you might have seen me before if you've attended any of those. But I am joined today by Advisor Plus HR Technical Consultant Emily Bennett and Senior HR Advisor Melissa New. So they're both here to share their expertise on the topics and kind of get into the practicalities on what you can be doing to prevent any risks as well. So over to the both of you if you'd like to introduce yourselves.
Hi, I'll go first. So my name is Emily. I have worked in HR for just coming up to 10 years now. And I've worked with a number of different business types as well. So I've worked in the health sector, I've worked with telecommunications, with utilities, and with builders merchants as well. So quite a breadth of different businesses. I have a level 7 CIPD qualification and a master's degree in HR management as well. And my role at Advisor Plus involves supporting the advisory team, so my colleagues like Melissa, with any complex and high risk cases that come through. And I also focus on upskilling and training the team on any new legislations or best practice that comes through as well. But I will now hand over to my colleague Melissa so that she can introduce herself as well.
Hi everyone, my name is Melissa. I have worked in HR for just over 6 years now. I have my level 5 CIPD qualification and my role at Advisor Plus is a senior HR advisor. So that means I work on the advice line supporting clients with their employee relation needs, covering topics such as the one we're covering today, and also along with discipline, grievance, flexible working, etc.
Fab, thank you so much to both of you. So yeah, that is who we are. Just a little bit about what we're going to be covering today too. So today the advisors will be focusing on the legal framework for maternity and paternity leave, and that does include eligibility and entitlements. They'll also be covering best practices for managing parental leave requests and accommodations, and then kind of addressing some common challenges that people might be facing and avoiding legal risks that might crop up too. So without further ado, we will get started. First topic I'd like to cover is with you, Emily, if that's okay. So starting with maternity leave, can you give us a bit of an overview of the legal framework for maternity leave?
Yeah, absolutely, no problem. So we'll start with the leave side of things. So for statutory maternity leave, it lasts for a maximum of 52 weeks and it's made up of 2 sections. So your first 26 weeks is referred to as ordinary maternity leave, or OML, and the second half, the last 26 weeks, is referred to as additional maternity leave, and that can be referred to as AML. So in terms of the leave, an employee doesn't have to take the whole of the 52 weeks. So what I'd say is it's always a really good idea to get an understanding of the employee's thoughts on how long they might want to take before they actually go on the leave. That then allows you as a business to plan ahead, think about any cover, any work reallocation that you might need to do, and just have a nice idea of when that employee might be thinking of coming back into the business again. Having said that, and we're going to refer to this a little bit throughout, the time off that they originally anticipate taking may change. So it's really important that as a business, you're open to this and you are open to the idea of flexibility and a little bit of agility there as well, because things can change for the employee before the leave, during the leave, and after the leave as well. So it's good to have that in mind. In terms of the kind of mandatory section of the leave, employees on maternity leave have to take 2 weeks leave immediately after the baby's born. That's 4 weeks if they work in a factory. So that's the absolute bare minimum that the employee needs to be taking from a legal perspective. In terms of when they can take it, usually the earliest that an employee can choose to start their leave is 11 weeks before the expected week of childbirth. Now, we're going to refer to this expected week of childbirth a couple of times, so I'll just explain what that means. So it refers to the Sunday before the due date of the baby, and it ends on the Saturday after. So if the employee's due date is a Sunday, then that's the start of the expected week of childbirth. If the employee's due date is a Wednesday or a Thursday, you're going to backdate that to the Sunday before, and that would be the start of the expected week of childbirth. So yes, the earliest that an employee can start their leave is 11 weeks before that expected week of childbirth, not the exact due date. However, there are a couple of examples of where the leave would automatically kick in as well. So the first one would be it automatically kicks in the day after the baby is born, even if that is more than 11 weeks before the expected week of childbirth. So for example, if the baby is born 15 weeks early, that leave would still kick in the day after the baby's born. It will also start automatically if the employee's off work for a pregnancy-related illness in the 4 weeks before the expected week of childbirth. So that's another time when it would automatically kick in, and they could go straight off on the maternity leave. In terms of the pay aspect of it, some employers choose to pay enhanced maternity pay, but I'm just going to focus on the statutory side of it for the moment. So the statutory payment is called statutory maternity pay. Sometimes this will be abbreviated to SMP. So SMP is paid for up to 39 weeks of the maternity leave. The first 6 weeks, an employee will be paid 90% of their average weekly earnings before tax, as long as they meet the eligibility criteria. After those first 6 weeks, the following 33 weeks will be paid at either the current rate of statutory maternity pay, which is £184.03, or 90% of their average weekly earnings, whichever is the lower. SMP would also be paid in the same way as the employee's wages. So for example, if you normally pay your employees weekly, it would go in weekly. If you pay them monthly, it'll go in monthly. And tax and national insurance would be deducted as normal as well.
Fab, thank you, Emily. Melissa as well, would you be able to talk us through the eligibility for maternity leave and pay?
Yeah, absolutely. So firstly, I would say it's important to understand that the eligibility for the leave itself is separate to eligibility for pay. So an employee can be eligible for maternity leave, however, ineligible for the maternity pay. So that's something to keep in mind. So we'll go over the eligibility for the maternity leave itself. So to be eligible for the leave, the employee must be an employee, so not a worker or contractor. They must be an employee, and they must give their employer the correct notice. So it doesn't matter how long they've been employed for or how many hours they work, how much they get paid. If they are an employee and they give the correct notice, then they are eligible for the leave. The correct notice is at least 15 weeks before the employee's due date. And as an employer, you can ask for this notification in writing if you wish. So to be eligible for the pay, however, the employee must earn an average of at least £123 per week, give the correct notice and proof that they're pregnant, and they must have worked for the business continuously for at least 26 weeks, continuing into the qualifying week. Again, that qualifying week is the 15th week before the expected week of childbirth.
Fab, thank you, Melissa. So that was a little bit more on maternity leave and pay and its eligibility. Moving on to paternity leave now. So Emily, can you give us the kind of headlines of what the legal framework for the paternity leave is?
Yeah, of course. So different to the maternity leave. So for paternity leave, if eligible, the employee can take either 1 or 2 weeks of paternity leave. If they do choose to take 2 weeks, the weeks can be taken together, or they can be taken separately, 1 week over here and 1 week over there. The employee does get the same amount of leave, even if there's more than one child in the birth. So if it's twins or triplets or anything like that, it's still just the 2 weeks. It doesn't get multiplied by each child. A week of leave is the same amount of days that the employee would normally work in a week. So for example, if the employee normally only works on Mondays and Tuesdays, then a week of leave will be classed as 2 days, not 7. Different to maternity leave. So paternity leave can't start before the birth of the child, and it must end within 52 weeks of the birth or the due date if the baby's early. So if the baby's born early, they get a little bit more flexibility in terms of when they can use it. The employee must give their employer 28 days notice if they want to change the start date of their paternity leave where reasonably practicable. And I think this is a point to remember for all these pieces of leave. We've already mentioned that, things can change, and this goes for maternity leave and for paternity leave. The employees might not be in a position to give you that notice, and you need to bear that in mind when you're trying to be supportive and act reasonably. It could be that the baby comes early, and so therefore they can't give you that 28 days notice because it's just happened all of a sudden. It could even be that they're not aware of the pregnancy until much later into it, or when the birth is happening. Those things can happen. So again, it wouldn't be reasonable to ask the employee to give us 28 days notice for something like that they don't know is going to happen. In terms of pay, the payment is the same. So the statutory weekly rate of paternity pay is currently £184.03, or 90% of the average weekly earnings, whichever is the lower. A key thing to remember here is this tends to change every April with the tax year, so you can check the government website for the correct figures. But yeah, currently it's £184.03.
Great, thanks, Emily. In terms of the eligibility criteria then for paternity leave, what is this, Melissa?
Okay, so to be eligible for paternity leave, you must be taking time off to look after the child, and you must be one of the following. So you must either be the father, the husband or partner of the mother, the child's adopter, or the intended parent if you're having a baby through surrogacy. So to be eligible for the paternity leave itself, the employee must be an employee, give the correct notice, and have been continuously employed by the business for at least 26 weeks up to any day in the qualifying week. And again, that qualifying week is the 15th week before the baby is due. To be eligible for the pay, the employee must be employed by the employer up to the date of the birth, and an average of £123 per week before tax. They must give the correct notice, and they must have been continuously employed by the employer for at least 26 weeks up to the end of any day in that qualifying week. As well as maternity and paternity leave, if eligible, both parents can apply for shared parental leave also, so that's something to bear in mind.
Yeah, thanks for that, Melissa. It's good to break all of that down. And there are other bits of leave. Melissa's obviously just mentioned shared parental leave, but there's other bits of leave that I think are important to mention at this point too. So this can be a very sensitive topic, but it is really important for us to cover and for you to be aware of as an employer, if unfortunately any of your employees end up in this situation, just so they know what's available to them and what support you can offer. So it's worth noting that employees can still get statutory maternity leave and pay if their baby is unfortunately stillborn after the start of their 24th week of pregnancy, or if the baby is born alive at any point during the pregnancy and then unfortunately dies after birth. Likewise, an employee can still get paternity leave and pay if their baby is, again, stillborn from 24 weeks of pregnancy, born alive at any point during the pregnancy. And another thing to note here is if the employee has already booked in their leave in anticipation of the baby coming, if they've done that before, they found out that they've lost the baby, then they can still take this leave that they've booked. If after they found out that they've lost the baby, they have leave left to book, then they can still book and take this, but they must do it within 8 weeks of the passing of the child. In addition to this, there is a new piece of legislation coming in very, very shortly, which is called the Neonatal Care Leave and Pay Bill. And that will be coming in April, and it will apply in respect to children who are born on or after the 6th of April this year. So for this, parents will be able to take up to 12 weeks of paid leave with a minimum entitlement of 1 week in addition to their other leave entitlements. So this is on top of maternity, paternity, or shared parental leave. Neonatal care leave, or NCL, will be a day one right, and it will apply to parents of babies who were admitted into hospital up to the age of 28 days and who have a continuous stay in the hospital of 7 full days or more. So the idea of this leave is to help parents who unfortunately have to spend that first bit of their time with their child and potentially, you know, in the hospital or in the intensive care unit. It just gives them an extra bit of leave there to account for that. In order to qualify for this leave, as with the other forms of leave, an employee will be required to be employed for a minimum of 26 weeks prior to the leave being requested, and earnings on average of at least £123 a week to get the pay. In terms of the time frame for this, the leave must be taken in the first 68 weeks of the baby's birth. What that accounts for is that obviously for maternity leave, that would kick in immediately the day after the baby is born. So what that means is if they do get the maximum of the 12 weeks, they could tag that onto the end of their maternity leave. So that's why you've got that extra time to say you need to take it within the first 68 weeks of the baby's birth.
Thank you, Emily. Thanks for covering those as well. Some good information to bear in mind. So we have kind of covered the basics with regards to maternity and paternity leave and the entitlement and eligibility. I did want to talk about some best practices for managing these leave requests and accommodations. So Melissa, do you have anything to add for that?
Yeah, absolutely. So the first thing we would recommend in relation to best practice would be to put a family-friendly policy in place. I would recommend that the policy embeds inclusivity for all family structures. The policy should acknowledge that not all families are the same, they don't all look the same, and they should be inclusive of all different variations of families, such as single parents, LGBTQ couples. The policy should provide flexibility for all parents, regardless of their gender identity or sexual orientation. So, for example, your policy could state birthing parent instead of mother, because this would be inclusive of any trans or non-binary employees, so something to consider. We'd recommend calling your policy your family-friendly policy rather than having separate maternity and paternity policies, because again, that helps with the inclusivity side of things. In addition, the policy needs to outline specific eligibility and notice requirements, outlining your employee's eligibility for the leave and exactly what processes they need to go through in order to notify the business. As a minimum, the policy should cover the statutory entitlements and eligibilities. However, if your business does have any additional pay, contractual pay, enhanced pay, then it should be included in the policy as well. The policy should outline the provisions during the leave as well, so consider kick days, what the employee can expect in terms of communication between them and the business during their leave. Where possible, the policy should also include any information on support beyond the maternity leave. So some examples of that could be outlining what your provisions are in terms of offering flexible working, breastfeeding or chest feeding facilities in the workplace, and any support for managing any kind of health conditions relating to the pregnancy or the childbirth itself. The policy should include safeguards against any unfair treatment and maternity discrimination. So employees should feel secure in their employment rights, that their maternity leave will not negatively impact their employment status or their career progression. In addition to the contents of the policy, you should also ensure that the policy is accessible and that all employees know where they're able to access that policy to read through it. It's also important to ensure that any kind of lines of management know and understand the policy, because in order for them to successfully navigate any requests, they need to know the policy inside out.
Yeah, there's some great points, Melissa, and I think the really key thing there is, you know, having that policy, it's not just a tick box exercise. You know, it is important that people know where to find it and that managers know the contents of it, again, so that they can offer the relevant support to people. There will be other things that they need to cover, not just for supporting that employee, but also thinking about how the leave could have an impact on the business. So, for example, other things that might be in there are different ways in which you can arrange maternity leave cover. So there's lots of ways to go about this. So it could be internally, it could be that you look to recruit externally, and businesses can consider different contract options. So you could look at fixed term contractors, you could look at secondments. It just all depends on what works best for them as a business, really. Where it's feasible and where it's possible to, we'd also recommend looking at ensuring there's a handover period before that employee goes off on their leave. This is just helpful for everyone. It gives the employee going on leave the opportunity to phase out of the role, and it gives the covering employee the opportunity to hit the ground running when taking over the role. It gives that opportunity for the two of them to talk, and for that employee that's going off on the leave to kind of download all of the information that they've got in their brain, and all those little bits that aren't written down on paper. It's that nice time for them to hand over. It would also give you as a business a fail-safe. So should anything occur which leads to the employee unexpectedly going off on their leave, say for example the baby arriving a couple of weeks earlier than maybe expected, it would be great for you as a business because you're potentially going to have somebody there already that maybe would have liked a bit longer but is ready to go for all intents and purposes. And I suppose this brings us on to the next recommendation, which is to make sure that you have an open dialogue with the employee going on leave. And as a business, as I've already mentioned, having an open mind that things can change last minute, whether that's because the baby decides when it comes and that's what everyone just has to go with, or whether that's the employee wants to change something because of their own circumstances. Having this open dialogue from the very start helps ensure that you're creating an inclusive and an approachable environment, because the best thing for everybody is for us all to be on the same page, to be supportive, and to understand where one another stand in terms of what the plans are. Whilst from an operational perspective, it would be absolutely ideal to know exactly what's going to happen and when. It's simply not always possible when it comes to parental leave. I'm sure that the employee themselves would absolutely love to know when that baby's going to make an appearance. But as we know, that's not the way of the world, unfortunately, a lot of the time. So there's lots of ways in which an employee's original plans don't work out, or they simply need to be changed. So for example, the baby might be born early, resulting in the leave starting earlier than anticipated. It could be that an employee decides to take their maternity leave at the earliest opportunity, which, as we've already mentioned, is 11 weeks before that expected week of childbirth. It may be that they change their mind towards the end of the pregnancy as to when they wish to take this. It might be that, they were hoping to work right up to the date, but actually, circumstances have changed and they want to pull that forward a little bit. Likewise, it's not just about when they go on the leave, but how long they're going to take. So the employee may initially indicate that they wish to just take the first 39 weeks of maternity leave, because they're the only ones that are paid. However, it might be that during the leave, they decide that they actually want to take the full 52 weeks. The other way, it could be that actually they go off and for whatever personal circumstances, they decide that they would like to come back to work earlier. The other thing to think about as well is that an employee may need to change their working pattern or their hours when they come back to work. Whether that's because they want to work part-time to spend time with the little one. It could be that they need to change their hours to help support them with childcare in terms of getting to and from nurseries and things like that. So that's another thing to bear in mind, is that sometimes when people come back from this leave, it might not be on the same hours or shift patterns that they were originally on. As Melissa's already advised, it's really important to have that policy in place which outlines provisions for requesting the leave, including notification requirements, but it's equally important to have an element of flexibility wherever possible, and to continue with that open dialogue with the employee so that they feel safe to discuss their requirements with the business, and that they feel supported if they do need to ask for something that maybe wasn't quite on the original plan.
Thank you, Emily. Great advice for businesses just to bear in mind there too. Something else I did want to cover was more on the kind of like legal risks with everything that we've spoke about so far. So what steps can businesses take to avoid kind of common challenges that you two have come across, and kind of avoid these legal risks as well?
Yeah, absolutely. I mean, the above best practices that we've just gone through will certainly support businesses in taking steps to avoid legal risks, but that's not always enough to avoid the potential legal risks when it comes to maternity protection. There's a number of common challenges and legal risks that arise from the very start of the pregnancy when an employee announces that either they or their partner is pregnant, and therefore it's important to ensure that you as a business are not discriminating and are being compliant from that start. So some of the common challenges and legal risks. One of them, once you know an employee is pregnant, you should have regular health and safety discussions with them. This is usually through a risk assessment, so a maternity risk assessment. And within that risk assessment, you should be looking at considering possible risks that may occur at different stages of the pregnancy, any medical advice that the employee may have received, and the type of work that they do as well. So the risk assessment should be carried out as soon as possible, as soon as you're made aware that the employee is pregnant. And then it should be revisited periodically throughout the pregnancy. I'd probably recommend that it's carried out as a minimum once per trimester, but certainly it should be carried out more regularly if there's been any changes in the employee's role, working environment, or any changes in the employee's health during the pregnancy as well. Should the risk assessment or discussions with the employee show that the risks do exist, then the business must take steps to either reduce the risk or remove the risk, and they can do that through reasonable adjustments. It's important to know that if it's not possible to change the working conditions or hours, then you must offer other suitable work for the employee, and this work must be at the same rate of pay and on terms that don't treat the employee any less favourably. So one example of a reasonable adjustment would be if an employee works in a factory and their role involves packing and heavy lifting, and following the risk assessment it's deemed that the heavy lifting is not safe for a pregnant employee. Therefore, the business places the employee on packing only and removes the heavy lifting part of the role until the maternity leave commences. So another common challenge during the pregnancy itself is pregnancy-related absences. And I must stress that you should record pregnancy-related absence separate from any other sickness absences. You shouldn't be counting pregnancy-related absences towards any reviews or absence triggers that you may have in place as a business. It's important that you can demonstrate and evidence a supportive approach for the employee, both during their absence, but also in supporting them in a successful return to work following the absence. Another common challenge which could also present legal risks is antenatal appointments and knowing what their entitlements is. So by law, pregnant employees have the right to reasonable time off with full pay for antenatal and pregnancy-related appointments. This is regardless of length of service or whether they work full-time, part-time, they have that right. In terms of what is considered as reasonable time off for an antenatal appointment, it should include the length of the appointment or class itself, and also the length of time it would take to travel to and from that appointment. So if your employee has an appointment in the middle of the working day or the middle of their shift, it's a good idea to talk with them openly about how long it'll take and what time they'll need. And you might also need to consider agreeing some temporary flexible working arrangements for them to be able to attend the appointment. So for example, it might be appropriate for you to allow the employee to work from home for the rest of the day if it would take too long for them to get back to the office. Or you could allow them to change their start and finish times to allow them to accommodate for the appointment as well. It's important to stress that you as the employer cannot make an employee change an antenatal appointment to a different time if they do not want to do so. So for the partner of the pregnant employee, they have the right to attend 2 antenatal appointments. This time off is usually unpaid and it's for a maximum of 6.5 hours for each appointment. And then the final recommendation to avoiding legal risks during the pregnancy itself goes back to that open dialogue theme that we've already touched upon. And this is ensuring that you just proactively discuss with the employee what their expectations are during their leave, and having these discussions in advance of the leave itself. When people go on maternity or paternity leave, it can be quite isolating because they're not going into the office, they're not logging in online, they're not in regular contact with their colleagues. And sometimes, people can go on leave, and when they come back, so much has changed. There could be new systems in place, new colleagues, a new dynamic can make them feel quite out of the loop. So whilst it's important to give the parents some space and time, it's equally important to make sure they feel included in any changes, any updates, what's going on in work, so that when they come back, it doesn't seem so alien to them. Therefore, it's a good idea to talk to the employee in advance of their leave, in terms of what their expectations are during their leave. So are they interested in any keep in touch days? Do they want to be kept up to date on business updates during their leave? If so, what does that look like? Would they like the odd telephone call from a welfare perspective? Would they like any business updates emailed to their personal email address? So it's about understanding what it is the employee would like in terms of contact during that leave.
Yeah, there's some really good points, Melissa. And I think that probably leads us nicely on to avoiding legal risk during the maternity leave itself. It's not just about the pregnancy when they're in the workplace, there's also the maternity leave itself to consider. So it is really important not to fall into that trap of out of sight, out of mind. Just because the employee is off on their maternity leave, you do need to remember that they are still a part of the team, they are still an employee, and any important business updates do need to be communicated to them. This would include things like possible vacancies. So if we're thinking of making sure that those colleagues who are off on the leave aren't placed at a detriment, if employees on leave are missing out on opportunities that they would have pursued had they have been in the workplace, so promotions or even side moves that they were interested in, we want to avoid that situation. So yeah, making sure they're aware of things like potential vacancies, and again, you can have that discussion with them about how they would want to know about that, as Melissa's already discussed. Unfortunately, if a redundancy situation occurs whilst they're off, it's also important to remember that they are still there and they are still a part of the team, and what protections are afforded to them. We have had cases where businesses have done redundancy processes and then realised that they've forgotten the employees who are off on sickness or off on things like maternity leave. There are legal protections in place for employees who are pregnant or who are on leave. So employees who've already told you that they're pregnant, right up until 18 months after the baby is born, or 2 weeks following a miscarriage within the first 24 weeks of pregnancy, get protections against redundancy. And there's also protections in place for employees who are on adoption leave or shared parental leave as well. And in terms of what this protection is, it basically means that if there's a redundancy situation, then that employee who has this protection should be offered any suitable alternative roles before any of the other colleagues. So essentially what that means is if they meet the minimum requirements for the suitable alternative job role, it should go to them before it goes to anybody else. Regarding the maternity leave itself, as Melissa has already mentioned, you should have set up with the employee before the leave as to what contact they would like to receive, and making sure that we're striking that balance of keeping them in the know, keeping them in the loop of what's going on, but also allowing them that time away from work for their leave. Contact should remain supportive as well, so you shouldn't be messaging them work questions, for example. They're meant to be off on leave. That's not the point of the contact. All those handovers should have been done well before they went off, so that we don't have to ask those type of questions. So yeah, any contact should be about how are you getting on, and as we've said, any important business updates that they've asked to be kept abreast of. To help with those ongoing communications and that ongoing relationship between you and the employee, you can also offer keeping in touch days, often referred to as KIT days. So these are by mutual agreement. So you, as the employer, you don't have to offer them if you don't want to. And likewise, the employee who is on the leave doesn't have to take you up on them either. So it is just if both of you are in agreement. They're quite a nice way to have the employee come into the workplace for a day. It helps with keeping that relationship going and helps with almost breaking the ice a little bit and keeping them up to date with what's going on. So before a kit day is confirmed, you and the employee should agree, number one, what work are they going to complete when they come in for the day? And number two, what pay they should receive for the day. To be clear, their pay needs to be at least the national minimum wage. Generally, for ease, most companies will just pay them the normal rate of pay that they would have got if they were in work doing their job anyway. But yeah, all of that should be discussed before they come in and do the work, just so, again, everybody knows where they're standing.
Fab, thanks, Emily. So talking about kind of after that maternity leave ends then, and it's time for the employee to return to work, what would you say to consider there?
Yeah, again, and I think this is a common trap that businesses can fall into is, we recognise that, pregnancy can bring a risk. We recognise that maternity leave is protected under the Equality Act. I think sometimes we don't remember that there are certain things we still need to do even after the maternity leave has ended. So there's some really good best practice that you can put in place. So as I've already mentioned, don't forget that redundancy protection continues even after the maternity leave ends. So it's 18 months after the birth of the baby. So bear that in mind. Regarding returning to work, it will depend on when in their maternity leave the employee is returning to work. And this goes back to the very, very start when we were talking about ordinary maternity leave, which is the first 26 weeks, or additional maternity leave, which was the later 26 weeks. So if the employee returns to work during the ordinary maternity leave or immediately after it finishes, they are entitled to return to the exact same job. If it's during the additional maternity leave, then the employee does still have the right to return to the same job on the same terms and conditions. But if that's not possible because there's been significant business change, then they could be offered a similar job. That job can't be on any worse terms than before, because again, that could be putting them at a detriment having been off on maternity leave. And again, if there's been a bigger scale redundancy situation, that would have been wrapped up as part of that redundancy process. I mentioned this earlier, but another thing you might want to think about is that you could get a potential flexible working request from the employee, either whilst they're still on maternity leave in preparation for them coming back, or maybe once they come back and they kind of get the lay of the land and decide what they want to do. So to be clear, they don't have to apply for flexible working. They might just want to come back on their normal hours, the same shift patterns that they worked before. But it's a good thing to have in the back of your mind that it can happen, and it's something to think about ahead of time. Employees have a right to submit a flexible working request to change their hours, to change their work patterns, or even to potentially ask for a change of location, so potentially to work from home if that's something that your business can accommodate. It is a statutory right to request a flexible working request, and any requests do have to be considered seriously by the business, and if they can be approved, they should be approved as long as you can reasonably accommodate it. Bear in mind that now legally any requests have to be dealt with within a 2-month period, and that includes any appeal as well, regardless of whether that employee is on maternity leave or not. So if you do receive a request, it's important to reach out to the employee as soon as possible to discuss when they want to start that formal process and start to look at getting that formal meeting in the diary, knowing that that 2 months time has kind of started. Remember that if you unreasonably decline the flexible working request, this could be seen as potential discrimination as well. Melissa's mentioned this before, but you should also consider that the employee may want to consider breast or chest feeding when they come back to work, or they might be looking to express milk whilst they're in the workplace. In terms of what you legally have to do, you should complete a specific risk assessment for employees who are continuing to breastfeed or chest feed or express, and you should also provide a suitable location for those employees to rest. Now, you don't have to legally provide rest breaks for colleagues to do this. You don't have to provide a place to breastfeed or chest feed or express milk, and you don't have to legally provide a place to store any expressed milk. However, this is seen as best practice, and it is seen as really good employment practice. It helps to support returning colleagues, and it helps you as a business by offering supportive measures like this. It can help with your engagement. It can help with the employee's morale on their return to work. The important thing to remember here is if you are going to offer, rest breaks and a place for this to happen, you should absolutely not be asking somebody to breastfeed, chest feed, or express milk in a toilet. It is not a suitable location. The location that you do offer them should be somewhere private, somewhere clean, and somewhere warm. So yeah, it's a really good opportunity to, really enhance that offering that you're giving them, showing that support for, those employees coming back into the workplace. But yeah, if you take anything from this, please do not ask an employee to do any of those things in a toilet.
Thanks, Emily. Yeah, totally agree with everything that you've said there. The toilet is not an ideal location for any of that, so thanks for explaining that. But yeah, I mean, throughout this whole session, you've both given me and the people watching really, really great advice, so thank you for that. And thanks for sharing your thoughts with us today too. So whilst that is the end of the content that we've got, it is now time for our live Q&A. We do have about 5-10 minutes or so to go through the rest of the webinar and kind of tackle some of these together. So there's been lots of questions coming in throughout the session. I have picked some which I think will kind of be most beneficial to a lot of people. But remember, if we don't get around to answering your questions, the lovely people at Advisor Plus will be following up with you afterwards. So they will be reaching out with an answer to your question. So don't worry if we don't get around to that in today's session. So yeah, let's go ahead with that first question that I've picked then. This one is for you, Emily. And this is relating to the shared parental leave that you mentioned before. So they've just said, you mentioned earlier something called shared parental leave. What is this used for?
Okay, so absolutely we can go over shared parental leave. It's one of those topics that sometimes strikes a bit of fear into people because it can feel a little bit complicated when you first start looking at it. But I will go through what the aim of shared parental leave is and the entitlements, just so you've all got a bit of an idea about what this is. So shared parental leave basically allows the two people who are responsible for the upbringing of the child to split that maternity leave entitlement and pay between one another. So this allows families a bit more flexibility regarding taking time off in the first year with the child. So to be eligible, the employee has to be responsible for the upbringing of the child. So for example, they need to be the biological parent, they need to be the partner of the biological parent, or they need to have adopted the child. Remember, if we're thinking about maternity leave, you've got 52 weeks, but the first 2 weeks have to be taken by the birthing parent legally, 4 weeks if it's a factory worker. So that's going to leave you with either 50 weeks or 48 weeks of leave that can then be split between the two parents. So to be clear, at this time, when we're referring to the upbringing of the child, it is regarding that kind of parental role. So you can't share this leave between things like grandparents or, your sibling who would be the aunt or uncle or, a close friend or anything like that. It doesn't work like that. So it is that kind of parental role involved in upbringing the child. So in terms of usage, it means that both parents could be off at the same time. So to give an example of that, you could have the birthing parent taking the 2 weeks of maternity leave, and then you could have the partner taking the 2 weeks that they get for paternity leave. So they're both off for those 2 weeks. You're then going to have 50 weeks left of this maternity leave. And what you could do, rather than the birthing parent taking it all, is you could split that 50 weeks into 25, and both parents could stay off for a further 25 weeks together. Or another way that you could use it is to take it in turns. So you can, allow the birthing parent to take a bit of time, then the other parent could take time, and then it can even go backwards and forwards a little bit. It just allows a bit more flexibility, whereas historically maybe you've got one parent that can only take a very short amount of time against another parent who can potentially take an entire year. It just is a really great way to give families more choice on what works best for them when it comes to, their personal circumstances, their financial circumstances, and what they really want to get out of, that first, year of having the child. So it's a really great opportunity to have a bit more flexibility with how that maternity leave entitlement is used across the couple.
Fab, that was a really great answer. Thanks, Emily. Just to let you all know watching as well, we do also have a recent webinar that we ran purely on shared parental pay. So me and Duncan went through that with everyone watching. So if any of you are wondering how to process this or kind of what this looks like in Sage 50 payroll, if you're Sage 50 payroll customers, we do have a recording of that webinar available, and that's just at sage.co.uk/webinars. So just bear that in mind. On to question 2 though, this one is for Melissa. So this person asked, how do I approach a colleague who's having a lot of sickness whilst pregnant?
Okay, that's a good question. The key thing to remember is that you can't discriminate against an employee who's pregnant or treat them unfavourably or unfairly because of their pregnancy. So if the colleague is having pregnancy-related absences, which causes a concern, such as morning sickness, then we should not be managing those in terms of handing out warnings, in terms of, adding those absences to absence triggers, as already previously advised. What you should be doing is, if someone is having a lot of sickness absences while they're pregnant, is trying to understand what you as a business can do to try and support them and considering any reasonable adjustments. So for example, if they're feeling more nauseous in the mornings with morning sickness, are you able to move their shift patterns as a temporary adjustment? Can you make sure that you put extra rest breaks in place for them? Can their duties been changed if they're absent because they're struggling with fatigue or ligament pain? Can we give them lighter duties? So again, bear in mind that you shouldn't be placing them at a disadvantage. So ideas like forcing them to reduce their hours and therefore them receiving less pay as a result of that is likely to be seen as a detrimental and discriminatory act. So it's about working with the employee around how you can support them. As we said earlier, if the employee does have a pregnancy-related absence within 4 weeks of the expected week of childbirth, then that maternity leave would automatically start.
Thanks, Melissa. Another one that I've got for you as well, which I picked out, is what happens to a colleague's entitlements if they leave the business before they have the baby?
Okay, this is an interesting question because it is something that can happen. It could be that the colleague decides to resign for whatever reason, or they're made redundant, or that they are dismissed for another reason not relating to the pregnancy. Just because an employee is not employed with the business at the time of the birth does not mean that they're not entitled to the maternity pay. This is all to do with what work the employee has done up to the qualifying week, which, as we've already touched upon, is 15 weeks before the expected week of childbirth. So as long as the employee had 26 weeks service by the end of that qualifying week, and they had earned that average of £123 a week for the 8 weeks leading up to the qualifying week, then they are still entitled to the statutory maternity pay, even if they are then dismissed or resign after this. If you do offer any type of enhanced maternity pay, then your policy can state what the eligibility criteria is for this. And that might be including that they must still be a current employee, for example, to be eligible for any enhanced pay. But either way, the statutory pay would be payable.
Thanks again, Melissa. I think we've got time for one more. I'm aware we've run over for a couple of minutes, so thanks for bearing with us. But this one's for Emily. So what do we do if we need to discipline someone who is pregnant or on maternity leave?
Yes, this can be quite a difficult situation, I suppose, to approach. I think what I'd say is, first, you need to approach this in a sensitive way. I mean, either because, number one, the colleague is pregnant, and want to be careful about how we're approaching that. Or because they're off on the maternity leave, and again, as we've discussed, we're not, wanting to reach out with work things where possible. But again, sometimes that's unavoidable, so I'll kind of go through that now. You need to make sure, as we've said the whole way through this, that you are not putting the employee at a detriment because they are pregnant or because they are on maternity leave. So examples of this might be, disciplining someone for missing a task because they were on maternity leave, or, disciplining someone because they asked for time off to attend an antenatal appointment, and you refused to let them go and they went anyway, for example, because as we've already said, they are legally entitled to that. That being said, incidents can occur while someone's pregnant or on maternity leave that don't look to be directly linked to the pregnancy, to the leave, and that need to be looked at. what I'd say is when you're investigating the issue, make sure that you listen to any mitigation, because something might not look like it's linked to the pregnancy or leave on the face of it, but it could turn out that it could be. And it's important that you understand that as a business before you start, deciding what to do next from a formal perspective. An example could be if it looks like, someone's willfully underperforming, that they're not getting to their deadlines, then they're missing tasks, they're forgetting to do things, and it looks like that's just all willful, a real big downturn, but actually that maybe the symptoms of the pregnancy that are contributing to that. So maybe they're really struggling with morning sickness and they're away from their laptop a lot more than they normally would be, and that's what's causing them to have this massive downturn in productivity, for example. That being said, there can be incidents that are completely unrelated, and you are absolutely entitled to continue to follow your disciplinary process with someone regardless of them being pregnant. If they're on maternity leave, what you want to consider is whether this can wait for them to come back. So, if they're due back in 2 weeks, can we wait? Or if it's something really minor, could we wait? But that being said, if it's serious and it's reasonable for us to continue, then ultimately, even though they're on maternity leave, they are still employed by us, by the business. So you can invite them in whilst they're on leave, as long as you've got a really good explanation as to why you couldn't wait, basically. In terms of sanctions, you can dismiss someone who's pregnant or on maternity leave for their actions for a disciplinary. Again, as long as you're comfortable that you've explored whether there were any potential discrimination risks, and that you're comfortable it had nothing to do with the pregnancy or the maternity leave. Examples I've come across on cases are things like theft, where the colleague has knowingly stolen something and they happened to be pregnant. Or if maybe they've bullied or harassed someone, if they've broken your, inclusion policy by using, certain slurs or language, again, nothing to do with the pregnancy or the leave, and certainly something that you'd want to deal with sooner rather than later. So they're just a couple, but there are other situations. So yeah, absolutely, you can discipline someone in that situation. You just need to, be really conscious of assessing the risk and making sure that you're not doing it because they are pregnant or because they're on leave.
Thank you so much, both of you there. Really great answers for them. Hopefully they've been helpful to everyone watching as well. That does look like it's all we've got time for in terms of the live Q&A, but we will again follow up with anyone whose question's been missed, so don't worry if we haven't got round to yours. But yeah, hopefully you found it a valuable session today. Emily and Melissa, thank you again. It has been great to present this with you both. Couple of things before we finish the webinar in terms of further support and further information on the things that we've discussed as well. So a little reminder that you can download the handouts from today. So we've got all of the slides that we've covered with the information on, including that fantastic summary document that Advisor Plus have provided for us. And if you would like any kind of help with anything that we've covered today or further advice, please do feel free to check out any of the topics covered in the Sage HR Advice portal. If you are a professional or premium customer, do not hesitate to call the advice line. One of the consultants will happily provide any guidance on anything that we've spoke about today. And just a couple more things to let you know about as well. So Sage HR Advice, first of all, this is here to help you navigate and simplify these proposed changes that we've mentioned. So especially with the kind of changing legislation and the new bill coming in from the 6th of April. And alongside that, we've got Sage HR2. So this can help you kind of automate and simplify a lot of the kind of day-to-day tasks that you'll be doing, like calculating holiday entitlement, shift scheduling, and kind of automatically logging hours and things like that. We do actually have webinar recordings and some of the different modules of Sage HR. So if you are interested in knowing a little bit more about those and kind of seeing them in action, I would definitely recommend watching those that me and Duncan have done. And yeah, we've actually got some really great new offerings in HR advice too, including small business toolkits. We've got a digital e-learn library as well, which does get regularly updated with new content, and some new additional services too. So things like on-site health and safety assessments, which should be really helpful. So fantastic new offerings for your business. I would highly recommend getting more information if that does sound like something that you would benefit from. And I will be launching a poll soon. So if that does sound like something that you want to know a little bit more on, you will be able to respond if you'd like more info. As for webinars, I did previously mention a little bit earlier in the session about kind of other webinars that we've done. So we do have more upcoming in terms of Sage 50 payroll, which is what I mainly support. But we do also have our next webinar with Advisor Plus booked in, and that is the 6th of March. That is going to be HR advice based on real scenarios and real advice. That was a great session when we did that last time, so I'm looking forward to that one again. Definitely have a read about what that's all about and get yourself signed up. Yeah, with that being said, that does bring us to a close. Massive thank you to everyone who stayed towards the end as well. I know we have run over a little bit, too much to talk about and cover today. Again, we will be following up with any unanswered questions. And then last thing from us, you will receive a short survey as you exit the webinar. Just a couple of questions about kind of how things have been. So if you do have just a minute to fill that out, we would really, really appreciate that. We do read every single comment that you leave us. We look at every single score and just really try to make these webinars the best that they can be. So yeah, that's it from us. Thank you again for everyone joining us today. Special thank you to Melissa and Emily for their expertise and advice too. Hopefully we will see you on another webinar very soon, maybe the quiz tomorrow if you're free. But yeah, from all of us, it is goodbye for now.